Yes, Mr. Racing.
I'd like, if I may, to revisit the issue that was raised before the luncheon adjournment concerning the lacuna issue, if I can call it that, and the question that was put to us, I think, by the lady, as to whether there is any guidance in the form of a manual or such like that is given to an administrator. As we understand it, the nearest thing to that would be statements of insolvency practice issued by R3, which is the trade body for insolvency practitioners. We have perused the material that is available, and we do not believe that there is any specific guidance on this issue. It is right that there is generic guidance that can be found on the government website relating to the filling in of the form HR1. But again, we don't think that that specifically addresses the position of an administrator or other office holder upon assuming office. Looking at the position rather more broadly, it is right to say that insolvency practitioners are regulated by recognised professional bodies, which are in turn supervised by the Department of Business. And they are the well-known bodies ICAEW, the IPA, ICAS, the Scottish body, ICAI, the Irish body. And of course, those bodies all will issue and require those persons who are regulated persons to abide by professional codes, the breach of which can give rise to professional disciplinary proceedings. And so I suppose in theory it might be said that the Secretary of State would have it within his power to make a complaint to a professional body concerning the behaviour of an insolvency practitioner. Returning briefly, if I may, to the misfeasance issue, I invited the court to have a look at what we said at digital page 119. It goes over the page, our paragraph 56, in which we consider whether, as a matter of practice and fact, it is likely that any person who is able to bring proceedings would in fact do so. And we note the company itself and the Secretary of State are not included within the exhaustive list of persons who are able to bring such proceedings or bring such action or application. Employees are capable of falling within the list as creditors, but we would say have little incentive to pursue the matter, since any loss is that of the company. And I know that Lord Richards pointed to the fact that the official receiver is also included in that list, and of course that's right. As a matter of practicality, it is unlikely, we believe, that the official receiver would be inclined to bring a misfeasance action. The official receiver is separate from the Secretary of State, although appointed by the Secretary of State. In practical terms, the official receiver is only likely to have an interest in administration if the administration is exited by way of a winding up by the court, in which circumstances, by virtue of section 132, or as the liquidator themselves, the official receiver would play a part. So, in short, we say that the lacuna is not filled. My Lord Reed invited us to give consideration to section 212. We did in fact touch upon section 212 in our written case at paragraph 74 on page 124. I think the court is looking at different pagination.
Yes.
Internal pagination 33. And we set out the history of section 212, specifically in relation to my learned friend's arguments concerning Johnson, the Johnson case. And the court will recall that the divisional court briefly observed that the difficulty in Johnson has subsequently been cured. The detail behind that is set out in our paragraph 74. The way in which section 212 initially cured the problem was that it included the person, the creature with which Johnson was concerned, which is a close equivalent of what became the administrative receiver, as a party that was subject to the misfeasance provision in the original iteration of section 212. That is to say, the one that was enacted in 1985, 1986. It presently does not include administrators within that list, but it did originally. Administrators were essentially shunted off as part of the amendments effected by the 2002 Enterprise Act, which took old Part 2, rejigged it and relocated it into Schedule B1. And so for that reason, we say that the impediment identified in Johnson to the application of the misfeasance provision to the receiver and manager in question has subsequently been overridden by express statutory words.
The original version we're looking first at subsection 1. It drew the same distinction between officers of the company in subsection 1A and administrators in subsection 1B. The only in fact, the current version seems to be the same as the of subsection 1 seems to be as originally enacted. There seem to have been words inserted in 1B at some point which have subsequently been taken out again.
I think what happened is that, as you said, administrators were originally included in section 2121B. Yep. So it referred to liquidator, administrator, or administrative receiver of the company.
Yes.
And then when Schedule B1 was brought in, administrator was deleted from paragraph B. And as you say, there's a separate provision in Schedule B1 dealing with administrators.
My Lord, yes.
But the point is really the division that is made in section 2121 between, in A, an officer of the company, and in B, looking at it as originally enacted, a liquidator, administrator, or administrative receiver of the company.
Yes.
And then C not being a person falling within paragraph A or B. So the point is, as is the case with the other sections to which Mr. Reid referred this morning, that an administrator is not being treated as an officer of the company.
Yes, for the purpose of this provision, which is concerned with the scope of the summary remedy, a civil remedy, for the purposes of misfeasance. So we would respectfully submit that it's of limited, that distinction is of limited significance in construing a different type of section, which is a standard form directors, etc., liability provision for the purposes of criminal proceedings.
Isn't the significance that the administrator, we're trying to determine whether this creature of the Insolvency Act 1986 is an officer of the company or not?
Yes.
So perhaps the first port of call is the Insolvency Act itself, which
Yes.
creates the administrator. And looking at this and other provisions, it seems to proceed, arguably proceeds on the basis that the administrator is not an officer of the company.
Yes, whether the categories are mutually exclusive for all purposes is perhaps a question that then arises.
So you're saying the term officer of a company may not have a fixed meaning wherever it appears in the statute, but one has to look at the context to see whether, for that purpose, it makes sense to include the administrator in the term, an officer or similar officer.
Yes, but Malaysia puts the point better than me. As with many lists in statutes, it is a convenient categorisation of those who fall under the scope of the duty or the application or whatever is the subject matter of the statute. It doesn't necessarily follow that the categories are all mutually exclusive. What he's trying to capture is the ordinary understanding of an officer of the company, directors, secretaries, managers in the conventional Companies Acts sense. In my respectful submission, does not cut across the construction that we and the divisional court in relation to a different type of provision performing a different type of function.
But even if we ignore paragraphs 45 and 64, and indeed everything in the Insolvency Act which distinguishes between an administrator on the one hand and an officer of a company on the other, is there any sense in which an administrator could be regarded as an officer of a company? Is he answerable to the company, for example, to its shareholders? Is he removable from office by the company or its shareholders?
These are rhetorical questions that obviously point to distinctions that are of relevance.
Yeah.
But
I mean, if the argument is ignore the Insolvency Act, he can be regarded as an officer of a company in some broader sense. Then we have to sort of ask ourselves, well, what do you mean by an officer of a company in the context of the provision that we're concerned with?
essentially, whoever's running the company at any particular time. We would respectfully submit that's plain.
It's a functional.
It is a functional definition.
A functional definition.
That is plainly what it is trying to do. And the language is slightly different as well, doesn't?
Anyone responsible for the conduct of a company's affairs? Would that be a...
My Lord, that is precisely the way we have always advanced our position.
Or anyone who is in a position where they are the ones who either do or don't give notice to the Secretary of State about impending redundancies.
Precisely. And the court has our arguments about this, that the function of giving notice to the Secretary of State is one that can only be performed by the administrator following administration, because it is a clerical function which falls squarely under the relevant provisions, and directors in the company itself are disbarred from performing those kinds of functions absent the consent of the administrator. So who else can do it? And who else can be described in the context of a post-administration corporation?
Just pursuing the functional definition a little, would it be your submission that an administrative receiver is an officer of the company for the purposes of the TELCRA provision?
It would certainly be our, this is perhaps an unhelpful answer, it would be our position that a liquidator is.
I'm specifically asking you about an administrative receiver.
My Lord, I think perhaps the simplest answer is, I'm not sure. I've been reminded of the terms of Section 251 of the Insolvency Act. I'm grateful.
Have we got that in the bundle?
I'm not sure it is in the bundle because we're
Okay.
we're going in a direction
Oh.
I had not anticipated, though no doubt I should have done.
Which section are we looking for?
My Lord, it's 251.
251. I don't think that's.
Yes. So it's the definition of administrative receiver, and it says, this is expressions used generally in this group of parts, except insofar as the context otherwise requires. Administrative receiver means an administrative receiver as defined by section 29(2) in chapter 1 of part 3.
So,
Yes. And officer is defined within the same interpretation section as being in relation to a body corporate includes a director, manager or secretary. Obviously a non-exhaustive definition. But it's right to say that section 251 defines an administrative receiver separately to officer,
so
which may indicate that administrative receivers on a certain view are outside the scope of the broader definition of officer.
I mean, if you put yourself in the position of the drafter of the 1975 Employment Protection Act, he would have before him the decision of the Court of Appeal in Reed Johnson Builders that a receiver is not an officer. So one would assume in those circumstances the drafter would not have in mind a receiver appointed by debenture holders as being an officer. So for an administrative receiver to be included in the definition of officer, there would have to be something attaching to that position which was in a sense created by the Insolvency Act to bring him within the definition of an officer, but it doesn't look as if there is.
Yes, I see the force of the observation that administrative receivers
Yes.
should be treated differently. And I was going to go on to say that your lordship got there ahead of me, that Johnson, of course, did treat administrative receivers as not being company officers.
Correct.
So there would be a reason for regarding them as falling within a different category. And that appears to be borne out by the way in which this has been drafted.
And then when we look at section 212, again, subsection 1, paragraph B, we find that liquidators and administrators are put in the same category as administrative receivers. At any rate, perhaps tends to suggest that they're in a different category from officers of the company.
Yes, well, I see the argument. I don't think that I can articulate my counter-argument again in a way that improves upon it.
Can I also ask you this? Supposing the court appointed a receiver, this is not a debenture holder's receiver, this is a receiver appointed under section 37 of the Senior Courts Act. Imagine you've got deadlock in a company, maybe there's an unfair prejudice petition has been presented, the company is rudderless, so the court appoints a receiver to manage the affairs of the company. So that's an officer of the court, it'd be an accountant probably, officer of the court, as it were, imposed on the company in that way. Would your submission be that court-appointed receiver would be an officer of the company for the purposes of Tulcra?
I think the answer is yes. Obviously, the terms of their appointment may play a part in determining the answer to that question, but
Well, if you're taking a functional approach, it would depend on the functions required of him by the court.
and that is what we have always said is the proper explanation of Johnson, that this was an administrative receiver in all but name, the precursor of perhaps that office, appointed to sell off the company property, essentially.
Yes, it was an enforcement of the security, wasn't it? Yes. Right.
See if I can rediscover where I am. The Lord, I wanted to make, if I could, a few general comments before looking at what it is useful, subject to the court's own guidance, to drill down into, about the consequences of taking the appellant's case at its highest. That would be, if one takes the appellant's main argument that at its highest, and the law as stated by the divisional court, it appears to amount to this, that administrators would be reluctant to accept appointment if they are given insufficient time to comply with the notification requirements in Tolrica because of the inescapable criminal liability that they would face if they have to make unavoidable swift dismissals in the interests of creditors. And we would say it is instructive to consider how that might play out as affecting the conduct of employers and administrators in a case of this kind, on the facts that are to be taken to be the facts for present purposes. Prior knowledge of the administrator, a pre-pack. On one view, the most likely consequence is that administrators advising employers in the run-up to a proposed administration would ensure that both the administration and the notification of the Secretary of State were not left so late as to create the predicament that the learned friend relies upon for the purposes of his hypothetical case. And whilst it may be that there would be a residue of cases in which administrators effectively, in the hypothetical case that learned friend advances, would find themselves in difficulty accepting an appointment and disinclined to do so, that would no doubt be a regrettable thing. But again, if one considers how that plays out, what it may do is cause employers with knowledge of the gradual rundown of a company not to leave it too late before taking appropriate advice and putting the company into administration. My Lord, I made an attempt to distill our points set out at the conclusion of the case for the respondent. They're set out in 6 points. But the court may think that they really break down into 2 essential points. One, I think, has been reflected back to me by my Lord Hodge. Since the administrators are running the company following their appointment and are the only persons with power to give them notice, they cannot be written out of the legislation by any of the devices advanced by the appellant.
Are you reading from your case there? Sorry, I didn't...
I'm not.
No, fine, that's fine, don't worry.
I'm trying to simplify it further.
Yes, sorry.
It's the running the company point.
Yes.
And we say that would defeat the purpose of the legislation, even if it gives rise to the unpalatable conflict that the Divisional Court detected. And that really encompasses our reasons 1 to 3 and 6. And then, as the court knows, we have suggested ways in which that harsh consequence envisaged by the Divisional Court might be mitigated. But that is, in a sense, and logically, very much a secondary position. We are with the Divisional Court with respect, in its view, that if there is that unpalatable conflict, well, so be it. Sometimes courts have to decide which of 2 statutory schemes trumps the other. And we respectfully submit that they made the right choice, that Tolrica should trump the Insolvency Act. Our secondary position, though, does raise the possibility of special circumstances applying, and we've also touched upon the possibility of directions resolving to some degree the perceived conflict. It's going to be helpful to address the court further on the ejusdem generis point, because, as my learned friend rightly points out, we have ended up more or less in the same position, save perhaps to make this observation. We have considered the learning relating to that principle, and in our respectful submission, it does apply to the construction of this provision, because it does what the ejusdem generis principle is intended to do, but does so by express words. And one significant point that one might derive from that learning is that the genus or category described by the general words, indicated by the specific words, is in fact wider than the specific words. Otherwise, the principle doesn't apply at all. It has no work to do. So it, properly understood, the principle delimits but points to a more expansive category than that which one would arrive at if one just took the specific words individually. And we respectfully submit that some of the submissions, at least historically, that have been made on behalf of Mr. Palmer have not really grappled with that point. We dealt with it from the outset by suggesting that, as we did to the district judge who took on the point, that the general phrase takes colour from all of the specific terms that are previously mentioned. And so it is right to approach it on the basis that one can have an individual who is at the least similar to a manager or director without having to go further. And indeed that's what the divisional court did in its decision. I'm going to attempt, if I may, to go on to our second reason, as we've categorised them at the conclusion of our case, which is concerned with the line of authorities involving Home Treat, In re Hartlebury printers, and the essential point that we make is that those cases have weight and logic behind them. They also have quantity behind them. And what they establish is that there is no incompatibility in an administrator being regarded as an officer. And we respectfully submit that they cannot be lightly dismissed in the way that the learned friend seeks to dismiss them by saying that Mr. Justice Harman was being nice to the office holder. Could I invite the court to go to Home Treat, which is in the main volume at tab 9, if that's of any use, or page 365 in the electronic bundle. And this was a case where the administrators were concerned with the question of whether the company was acting ultra vires its original objects clause in its memorandum by running the company as a nursing home. The administrator sought prospective statutory relief afforded by the then provision, section 727 of the Companies Act 1985, to company officers for defaults, etc., where they have acted honestly and reasonably and ought fairly to be excused. And the essential reasons with which we are concerned can be found towards the end of the judgment at, using the bundle pagination, page 369, beginning at letter G. And I'll go to it if I may, but perhaps I should set out what I'm seeking to extract from it first. And it's essentially this. the reasoning was based on the fact that the administrators were conducting the business of the company. Point that we rely upon.
Where is that said, sorry?
My Lord, perhaps it would be simpler if I...
Just show me where that is said.
Yes.
I mean, is that Mr. Justice Harmon's reasoning to his result?
My Lord, it is at page 370A.
Yes, I see. It's the paragraph at the foot of 369. Upon that basis, Mr. Brisby submits, isn't
My
it?
Lord, yes.
Right, thank you.
So first of all, he refers to the decision of Lord Parker of... Mr. Justice Parker, who later became Lord Parker of Waddington.
It was the fact that it was the fact that the liquidator was doing certain acts for the company. Yes. It seemed to have been influential there.
My Lord, yes. So we can go to the X. It's in the bundle. But first of all, attention was drawn to that case, which concerned a liquidator, and then he goes on in the paragraph below. Upon that basis, Mr. Brisby submits to me that an administrator appointed by the court to conduct the business of the company, so we have it there again, with a view to a better realisation of its assets, or indeed, as in this case, with a view to the survival of the undertaking or part thereof, as a going concern, must surely, even more than a liquidator, be a person properly within the context an officer of the company. Mr. Brisby puts it that on the words of the English language, an administrator plainly holds an office, that is certainly correct. He is an officer of the court, that is undoubtedly correct. He is also, by conducting the business of the company, as it seems to me, an officer of the company. He is appointed under Section 8.2 of the Insolvency Act, 1986, obviously that's old part 2, by an order directing that the affairs, business and property of the company shall be managed by the administrator. And pausing there, these are all points that we seek to rely upon with reference to the provisions of Schedule B1. And then he goes on, it seems to me quite clear that the word officer, which merely means somebody who holds an office, and an office in relation to the company, can apply to an administrator. That is so, although he is also an officer of the court, there being in that context no conflict of duties between his duty as officer of the company and his duty as an officer of the court. In both capacities, his duties are to manage the business and property of the company for the better effecting of the purpose for which the court made the order, in the interests of the creditors, and it may be eventually of the contributories of the company. And,
Does he set out, I was just looking for the text of section 727, does
I'm
sure I could find it.
yes, would you lordship give me a moment? Yes, page 369F, I think.
Right.
No, he refers to it, I beg your pardon, he refers to it at page
So-
369F.
So it appears to be against it says an officer of the company or person employed by the company.
Yes.
Yeah. An officer was a defined term, wasn't it? So this is the Companies Act 1985.
It is the precise precursor of section 1157 of the 2006 Companies Act.
So that definition hasn't changed at all between the two
I
acts.
believe that is the case. Right.
11.
It was also summarised.
Oh, hold on. We've got section 744, haven't we? At page 301, which is the definition section from the Companies Act 1985, which defines officer, yes, in relation to a body corporate includes a director, manager or secretary. Yes, thank you.
Yeah, the definition of manager, of officer now is in 1173, subsection 1. And it defines officer, or says officer, in relation to a body corporate includes a director, manager or secretary.
Which is the same as 744 of the 85 Act, yes.
My Lord, the case referred to Re-X, which we've already touched upon. I'm not sure that it's going to greatly advance the argument by going to it. The treatment of the issue by Mr. Justice Parker, as the name was, is fairly brief, and it was based on giving the liquidator leave to pay stamp duty on the footing, I quote, on the footing that he was a company officer. That is at the bundle, tab 10 if you have such a thing, otherwise it is page 371. Perhaps the most pertinent passage is at 373 at the bottom, where in the course of argument, Mr. Justice Parker said, the only question is whether the applicant is a voluntary liquidator who is an officer of the company. He has all the powers of the company subject to certain statutory limitations. So essentially the same point that we seek to rely upon, a functional assessment based on the functions accorded to the office holder, which amount to running the company. The next in the sequence is powertrain, which the court will find at page 376 in the digital bundle. And this was a case which concerned a subsidiary of the NG Rover Group. Liquidators applied to be authorised to effect further distributions in favour of the company's known creditors, notwithstanding that further claims could in theory emerge, and the liquidators sought prospective relief under section 1157 of the Companies Act, so we would say the equivalent of the provision considered by Mr. Justice Harman. Mr. Justice Newey, as he then was, set out his reasoning at page 379 in the digital bundle. And we have paragraph numbering. So paragraph 11 is reference to section 1157. Paragraph 12, question posed are liquidators officers for the purposes of section 1157. Paragraph 13. In Rawnsley and Wetherall Green and Smith North Limited, His Honour Judge Berren, sitting as a judge of the High Court, said of his judgment that to his mind it was seriously arguable that a liquidator is not within the ambit of section 1157. So far as can be seen from Judge Berren's judgment, however, he was not referred to the authorities to which I have been taken and which indicate that a liquidator is within the scope of section 1157. In that connection, I was referred to the decision of Parker J in Re X, to the decision of Harmon J in Re Home Treat, and to passages in Key Macpherson Law of Company Liquidation, Lightman and Moss. I think we've not included that passage. Those various sources provide substantial support for the proposition that a liquidator is an officer for the purposes of section 1157 of the Act. The most helpful authority is perhaps Home Treat, where Mr. Justice Harmon was concerned with the position of an administrator and expressed the view that it was quite clear that the word officer, which merely means somebody who holds an office, and an office in relation to the company can apply to an administrator. Mr. Justice Harmon's reasoning in Home Treat appears to me to be equally applicable to the position of a liquidator, and I shall accordingly follow that case and hold that a liquidator can be granted relief under section 1157.
It's rather surprising in a way, isn't it, that after the bifurcation that occurred with the Insolvency Act 1986, where insolvency goes into one act and, as it were, living companies remain in the Companies Act, that a liquidator or administrator should be seeking to make application under the Companies Act. It just seems very odd. It's not entirely clear to me why they couldn't simply rely on a direction of the court. They're officers of the court. If they comply with the direction of the court to take a particular step, it's not clear to me how they could subsequently be held liable for misfeasance, even if it involves carrying on an ultra vires business. Anyway, there it is. They asked for it, and that was the conclusion reached on the definition of officer in a different act.
Well, my Lord, yes, I respectfully agree that a direction of the court will provide insulation from liability by any action brought by an aggrieved creditor. The final case in the sequence is at page 380 in the digital bundle. The Schofield case, comparatively recent case of the Court of Appeal Civil Division. One notes that amongst the Lord Justices sitting was Lord Justice Newey, who of course was the judge who decided Powertrain.
He gives the judgment in this case too.
He does. And the facts are summarised in the head note. H3 and H7 are perhaps the most useful paragraphs. The joint administrators of the Rhino Group returned the companies to the control of their boards and were discharged. The ultimate, Schofield, that is, the ultimate owner of the group, instigated proceedings against Barclays, who had called in their loans, resulting in the administration. Following mediation, those proceedings were settled by a settlement agreement under which the, I quote, released parties, that was a term, included their affiliates, with affiliates being defined in turn as including an employee of the person, which in turn was defined as including officers and agents. So this was under the terms of the settlement agreement. Subsequently, a group company commenced proceedings against the joint administrators. And the issue arose as to whether the administrators were employees and officers. The judge struck out the claim, and on appeal, it was held that the judge had been right to strike out the claims against the administrators on the basis that, citing the usual authorities and indeed adding the Divisional Court's decision in this matter, that indeed the office holder was an administrator, and the passage to go to is paragraphs 51 to 53 at page 395. 51, it deals with the definitions. And then over the page, this may be of significance. In that connection, Mr. Tom Smith, Queen's Counsel, who appeared for the JAs with Miss, I don't need to give the names, pointed out that paragraph 69 of Schedule B1 of the 1986 Act states in terms that, quote, in exercising his function under this schedule, the administrator of a company acts as its agent. So we attach importance to that, that particular importance was attached to that provision, a provision which my learned friend invites the court to conclude takes an administrator outside the scope of what is connoted by an officer. And it then goes on to cite the authorities that we've looked at and adds the Divisional Court's decision in this matter. And it says, Mr. Smith said that the authorities show that administrators are officers. It goes on to say, for his part, Mr. Davies argued that an administrator is imposed on a company, acts primarily in the interests of its creditors, and would not normally be referred to as an affiliate of the company in question. Well, pausing there, these are precisely the arguments the learned friend advances. And then it goes on at paragraph 53. In my view, however, the judge was right to regard the joint administrators as affiliates within the meaning of the settlement agreement. The simple fact is that the joint administrators were both officers and agents of REL Properties and Asquith, and so they naturally come within the definition of employee and hence those of affiliate and released parties. So we would respectfully submit that there is a significant and well-reasoned body of opinion ending with that case to the effect that there is no repugnance in an administrator or indeed other office holders being regarded simultaneously as officers of the court or agents, but also officers of the company for the purposes of statutory provisions. I said that was the last in the line. In fact, I haven't addressed the court on the Hartlebury Printers case, which comes earlier in the sequence. Could I invite the court to go to page 353 in the digital bundle? We've touched upon the Hartlebury Printers in other contexts because it has something interesting to say on a number of points that arise in this case. For present purposes, the point that I'm developing is that there is no offensive incompatibility in the two statutory schemes, but it also says something of considerable importance, touched upon by the Lord Richards, about the circumstances in which administration can be special circumstances, not administration simpliciter, but administration, one might call it administration plus, can be a special circumstance. And then there is also a point concerning whether a court order negates the inference that an office holder makes a triggering proposal for the purposes of the notification and consultation provisions. But focusing on the first point, the repugnant incompatibility, again, the arguments were remarkably close to those that my learned friend advances. The administrators were arguing that they were outside the reach of the consultation and notification duty in the precursor 75 scheme, 1975 Employment Protection Act. And could I invite the court to go, first of all, to page 363 in the digital bundle. At letter B, well, in fact, the first paragraph down, the administrators, as responsible insolvency practitioners, are greatly concerned at the suggestion that the duty imposed on the employer by section 99 and 100, which is the consultation and notification provisions, so both were considered, although this was primarily a consultation case, must be observed by them given their status, functions and responsibilities under Part 2 of the Insolvency Act 1986. An administrator is an officer of the court. He has the powers conferred by Schedule 1, which include the power to dismiss the company's employees. In exercising his powers, he is deemed to act as the company's agent. So essentially all the points that the learned friend picks out as making an administrator incompatible with the officer described in Tolrica.
But I can see this point if what one was looking at was the question of whether the duty to notify the Secretary of State was a duty, if it was a duty imposed on the employer and on an officer of the company, one might say, well, an administrator should be under that duty to notify because once appointed they are exercising the functions of the officer. But we're not dealing with that. What we're dealing with is a provision which imposes criminal liability rather than imposes criminal liability for the failure of the company to notify, not a provision which imposes a separate duty to notify. So it seems to me a difference between the Section 188 issues and the Section 184 issue, which is not whether the administrator, qua employer, should notify, but whether they should be guilty of a criminal offence if the employer doesn't notify. And isn't that a slightly different question that is not answered simply by looking at their functional role?
I agree that it's a slightly different question, but I maintain the submission that looking at the wording and purpose of the section is designed to pick out and identify those who are running the company at any one particular time. But I accept the point that there are two separate stages in section 193 and 194. I also accept the point, and it's a point that my learned friend makes, that many of these cases are concerned with decisions that inured to the benefit of the applicant office holder, whereas we're talking about criminalising defaults by an office holder. But nonetheless, in my respectful submission, the same principles apply. They're either an officer because of what they do and how their functions are defined, or they're not.
I mean, this case doesn't address, does it, whether administrators are officers of the company for any purposes. I mean, the case the administrators were making appears at the paragraph just under letter D.
Yes.
It submitted that the proposal is that of the administrators, not as agents for the company, but as officers of the court.
Yes.
And that therefore the company was said wasn't proposing to make anyone redundant. It was the administrators
Yes.
as officers of the court. And Mr. Justice Morritt rejected that submission for really on account of the provisions to which he's just referred, that
Yes.
the administrator is an agent of the company because the statute so provides.
Yes, the question was a slightly different one, but the reasoning in my respectful submission nonetheless applies to the point
But
with
it
which...
is similar to the point that I was just making, isn't
Yes.
it? Who is the employer?
Yeah.
For the purposes of section 1931, does the employer really cease to exist once the administrator has taken over? Answer, no.
No.
But we're not here talking about... nobody is arguing that looking at 1941, the employer cannot commit an offence once an administrator is in place, because that would be equivalent to what was being rejected in this case.
Yes.
But it's a slightly different question as to whether, in addition to the employer, through the agency of the administrator committing the offence, the administrator commits the offence.
Yes. There are those two different levels that apply to the notification, liability, and here we're dealing with the consultation duty, which is slightly different. But nonetheless, they were trying to, if I can use the vernacular, get off the hook by advancing arguments that were remarkably similar to those that are advanced by my learned friend. And if one looks at letter E at page 363, it says, in terms, it is contended that the duty imposed by Section 99 of the Employment Protection Act on the company and the duties imposed on the administrators by the Insolvency Act are so mutually repugnant that they cannot exist side by side.
Where are you reading from? I'm so sorry.
My Lord, it is paragraph E at 363.
But it's between D and E that you were reading, I think.
Yes.
It's about the middle of the page.
DT, yes. Thank you.
And we would respectfully submit that the reasoning that follows towards the bottom of the page, which gives essentially the reasons, are apposite, that to do as the administrators contend, this is directly adjacent to letter H, would give rise to a breach of the UK's obligations.
I mean, this authority is, I mean, I don't think this is it relevant to whether administrators are officers. It's relevant to the, Clerks of Hove point, isn't it?
My Lord, it is.
Yeah.
I could, if convenient to the court, I was see if I can go to what I say about that.
I mean, he deals with it, page 364 in the electronic bundle, in the paragraph beginning, "In my judgment, it is plain."
Yes, precisely. This is what I described as the administration plus point. So it says, in my judgment, it is plain that an administration order does not per se render it impracticable for the company employer to comply with those requirements. And pausing there, that was in the context of having, first of all, examined the Clerk of Hove's case and its position that administration simpliciter, or per se, did not amount to special circumstances. But not shutting the door on a wider contextual analysis. And he goes on to say, it may or may not, depending on the other circumstances of the case. Those circumstances would have to be considered in the light of the duties and responsibilities of the administrator. A combination of those circumstances and the existence of an administration order may well give rise to special circumstances within section 99(8), when neither would when taken in isolation. And that is essentially the position that we advance as a potential solution to the difficulty identified by the divisional court. So I think it may be convenient if I state my position re special circumstances rather more broadly. And what I should like to do, respectfully, is to adopt a formulation articulated by my Lord Richards this morning, which consists of really a two-part question. First, is administration a special circumstance? Well, in many cases, it will be. If so, does it render it not reasonably practicable to comply with the notice requirements? And that ties in, we would respectfully submit, with the approach of Mr. Justice Morritt, as he then was, in Hartlebury Printers. It's consistent with Clerk of Hove's that administration per se or administration simpliciter is not enough, but administration plus, as I've characterised it, is capable, depending upon the circumstances, of being enough. And we would respectfully enumerate the considerations that come into play as consisting of these. It may not be an exhaustive list. The circumstances of the company or the administration, that is to say the fact-specific circumstances, and the question of how they bear upon the need to make dismissals or the need to make dismissals swiftly.
Well, that's just restating the question, but can you give some examples of when you think it will be a special circumstance and when it won't?
In the hypothetical case, as distinct from the agreed facts relating to this case, articulated by my learned friend, the court may think that those are capable of giving rise to a special circumstances defence. An administrator who has no prior knowledge of the gradual rundown of the company, is not involved in advising the company in advance, and assumes office, concludes properly and fairly that there really is no alternative to letting at least some of the employees go by way of swift redundancies to avoid the 14-day problem that one friend speaks about. And in those circumstances, one is entitled, on the approach adopted by Mr. Justice Morritt, to have regard to those duties and responsibilities. So we pose the question, why shouldn't an administrator be able to say, in those circumstances, I don't rely on the mere fact of administration in a gradual rundown case. What I rely upon is the fact that I've assumed office on Monday, having known nothing about this company, and I'm now faced with this dilemma.
But my difficulty with that is that the special circumstance defence relates not just to the administrator but to the company. I mean, if there are special circumstances, it would let the company off the hook, including those directors who should have given consideration to this before they appointed the administrator.
Well, my lord, if the offence is a continuing offence, which is the way it's been charged in this case, one is entitled, is one not, to have regard to the different periods in time. That is to say, the time running up to the administration, for which the directors are responsible, and the time thereafter, following the administration, where a new clock starts ticking. Obviously, as...
Why does the new clock start ticking as far as the company is concerned?
Because the question is whether the company continues to commit the offence.
But why shouldn't they, if the administrator is its agent? On your approach.
Trying to consider whether there is a passage in which we have dealt with our approach. Would your lordship give me a moment? It's, I think, at our page, digital bundle, page 112. It's the written case, so I remind myself, paragraph numbers are more useful. Paragraph 39.8.
39. Thank you.
So essentially what we say is that in the post-administration period, the question of whether the employer continues to commit the offence must be viewed through the prism of the administrator who is running the company rather than the previous management who have no independent power to do so. That
The offence is committed when the deadline by which you have to give notice has expired. So you've got to give notice within 90 days, whatever, or it's difficult because it's counted back from
It's counted back.
It's counted back, right. So But assume that before the administration starts, the deadline under section 193(1) or 2 has already expired. But then if there's a special circumstance intervenes, does that then create a new deadline within which the notice can be given and during which there is no further criminal offences charged until that reasonably practicable period has finished? I just don't see how that works. I don't see that the special circumstance can trigger some kind of suspension of the criminal offence which is being committed because the deadline has already expired.
Oh. But the odd thing about the deadline is that you don't know it's expired until the notices of termination are given, because you then count back from then.
Yeah.
Yes, I mean, the divisional court, of course, was of the view that the deadline was determined by the date at which it was proposed that the first of the dismissals would take effect, as opposed to the date at which dismissals,
I see.
and indeed, that it wouldn't matter if there were no dismissals.
But what is, so that, I mean, it would be useful to see some kind of worked example with actual dates, but if your assumption is, in the prosecutions that you brought, the assumption was that before the administration happened, there were already offences being committed, so the deadline for giving notice must already have expired.
Yes.
Now, if the administration is somehow a special circumstance, as at that date, is there some resuscitation of or some fresh deadline coming into effect? Or doesn't seem to be what's provided for in the legislation.
No, I accept that there's one deadline, unless one is dealing with a separate and different proposal. But once a
Let's
proposal...
assume we're not.
Let's assume we're not. So one is dealing with one deadline. So in a case of this kind, circumstances may come to a head which don't give one time to comply fully with the requirement facing the employer, but as soon as the triggering event occurs, there is an obligation under sections 193 and 194 to do all that is reasonably practicable to comply with it. So you give notice as soon as you possibly can. If the employers fail to give notice as soon as they possibly could, then they will be guilty of the criminal offence.
I mean, the way I read your paragraph 39.8 is that there is a continuing breach by the company. I mean, you're postulating that the directors, prior to administration, have well-formed proposals for redundancies.
Yes.
So you're postulating that the company as employer is committing the offence of failing to give notice. But the division into periods is for the purposes of determining whether, prior to liquidation, the directors and post-administration, the administrator, have committed the accessory offence.
Yes.
And you rightly say in the last sentence, or last two sentences of this paragraph, that whether the directors may well have committed an offence, the accessory offence, but whether the administrator has done so post-administration all depends on the circumstances.
Yes.
And I mean, I mean, I can see the good sense of that analysis.
Under circumstances as to whether they're treated as consenting or conniving. But I can't at the moment see how the question of it being a special circumstance can assist the administrator unless somewhere in section 194 the officer has some separate and potentially longer period in which to make the notification.
Oh, sorry, whether the employer does. Yeah.
Yes, I'm not sure that I can say any more that will assist your ladyship.
It's my difficulty is simply that it seems to me whether the directors are there, if the company has committed an offence by the directors coming up with this pre-packed proposal, which they know will result in redundancies and the fact that they then implemented by appointing a receiver, I don't see, or an administrator, I don't see why that in any sense gets the company off the hook. One may have to look at the accessory liability of the directors pre-administration and then ask questions about the administrator's accessory liability afterwards. But it seems to me that the company doesn't have a defence that's separate of special circumstances at all. Because all that's being done is the pre-packed plan is being carried out.
Yes.
As the directors intended.
Well, my lady and my lord are obviously right that the only way in which one can employ the special circumstance to the benefit of a liquidator upon assuming office is by taking the view that at that point it can apply to the company because it's the company that has the special circumstance. I say defence. I use that as shorthand. Because subsection 7 of section 193 is specifically anchored to the role of the employer.
That's really what I'm getting at. If it's not a defence, if it's not a defence in inverted commas, if it's not a defence for the company, I don't see how it could be prayed in aid for the administrator. And therefore, one of the two means that you have for softening the blow, as it were, for the administrator seems to me to fly away.
Yes. An alternative way of looking at it, which perhaps colours the approach that we have here, is that the company can only commit offences through the medium of the persons, the individuals, the natural persons running the company. And where that natural person takes appropriate action as soon as it is open to them to do so, why shouldn't the continuing offence stop at that point? Because the company is no longer committing it, because the person running the company has given notice. As I've said, we've raised these issues because we are trying to, as it were, assist the court. It is without prejudice to my primary position, which is If it doesn't work, it doesn't work.
Well, I thought your primary position was actually it did work, and that properly applied, the special circumstances defence will actually resolve the dilemma.
That is work.
But if that doesn't work, you say, well, so be it, which is a bit of a counsel of despair, given that your client department was responsible, as I understand it, for both sets of legislation.
Well, my lord, your lordship has summarised my position accurately.
Can I just ask you this? We were told by Mr. Reed that, to his knowledge, there'd only ever been 2 prosecutions, one of which is this case. One imagines that there have been thousands of cases in which redundancies have been made by administrators without full or, in many cases, any compliance with the requirements of TULCRA. Why haven't there been more prosecution?
I'm not sure that I'm in a position to answer that in a way that would be useful to your lordship.
It wouldn't seem to be a major problem, this.
That doesn't necessarily follow. Sometimes government departments acquire an appetite to prosecute particular offences in the light of prevailing conditions.
I see, yes.
And sometimes they pick and choose carefully those that they seek to prosecute.
Right.
My lords, I had intended, I've danced around a little bit by going to Hartlebury. I had intended to look at Clerks of Home itself.
We're going to have to be very quick.
I think I am, looking at the time. The essential point that I would seek to make in relation to Clerks of Home itself is that the contrasting concepts of a gradual rundown, which might indicate that special circumstances don't arise, and a sudden disaster, which indicates that special circumstances may be indicated, are just examples.
The part of a spectrum.
Precisely. And it is not, if a careful reading of that decision in the way that we've set out in our written case indicates that they were not formulating a principle of law that a gradual rundown case does not permit special circumstances to be advanced. And in our respectful submission, a reading of the approach adopted by the Divisional Court was to adopt an overly formulaic approach to the application of Clerk of Hoves. We would submit, for the reasons that we've put in our written case, that the recent decision of Carillion supports that construction of clerks and supports the broader approach that we have advanced, namely that although administration per se is not a special circumstance, administration plus is capable of being one. Lords, I did have submissions on the potential effect of directions, but I think that my time is up, so I would be content to rely upon what we have said in our written case, unless I can assist your lordships with any particular matter.
Thank you very much, Mr. Rosen. Mr. Reid?
May I begin by following up two matters that arose out of this morning? Firstly, my Lady Rose, in relation to the question about the broader background in relation to matters. I agree substantially with my learned friend about aspects of the regulatory background behind. I think we need to be clear about a couple of things. There was a change in the regulatory structure in 2015, and my learned friend refers to one of the trade bodies, R3, issuing insolvency statements of practice. There has been since then something called the Joint Insolvency Committee, to which various bodies are parties, including the Insolvency Service, and they issue statements of insolvency practice. And I agree with my learned friend that there's nothing there that deals with the particular view to be taken here.
But is there anything at all in there to do with sending this notice to the Secretary of State if you realise you're going to have to make redundancies?
Not in terms of statements of practice that have been issued. There's also a code of ethics for insolvency practitioners. The code of ethics for insolvency practitioners, the relevant code was one adopted in 2009 to 2020, and that code of ethics against which their conduct is judged for their registration purposes includes obligations of, as one might expect, about their professional conduct, and an obligation to comply with statutory obligations. But of course, those statutory obligations include both their Insolvency Act obligations and their Tolka obligations. But there's nothing direct. I think the blunt answer to your question is that, as was put, I think, in the question implicitly by your lordships, is that this is something much honoured in the breach rather than the observance, and that for many years insolvency practitioners have adopted a practice of making redundancies. They may, and I appreciate that the case against my client is that by neglect he failed to serve it at the appropriate time. But of course, even if it had been served on the day of the dismissals, it still wouldn't have been 30 days before the notice. That the practice has existed for many years of people adopting simply acting, and that there have been no prosecutions. And the people who might be most aggrieved in relation to the lack of any consultation rather than the notification would, as I indicated this morning, be the workers involved in the organisation. And although they don't recover in the administration the full amount of any protective award of 90 days, the normal practice is that they end up claiming from the redundancy payments fund a partial payment on the protective award. And again, my experience is that what happens is that the administrator will normally allow a claim for protective awards to be brought in the employment tribunal. An award is made of a protective award, and then people have been handed out the forms to claim from the redundancy payment fund the appropriate amounts at the time that they were dismissed. And the party effectively who carries the financial burden of the failure is the state, because it's picked up in part through the redundancy payments fund. Now that's just a broader picture, but that is the reality. So the answer, and we've had some further inquiries about whether or not there's any specific grappling with this position, and so far as we're aware, there isn't. So in broad terms, this is something that had existed as practice. This prosecution and the two prosecutions raised an area of concern. There haven't, so far as I'm aware, been any more, but it doesn't change the vulnerability that exists in relation to the criminal sanction. That still remains on the statute book.
Does it seem that the Hartlebury printers case, which clarified that this duty under section 1931 has to be performed by the administrator, that doesn't seem to have prompted any greater compliance, something like that, with administrators co-employer with the obligation.
Yes. Putting the facts of this case to one side, where there was on the prosecution case against me, a failure to deal with on the day of the redundancy, in the typical case, to take the pre-pack case, what you would typically see happen is the notification being given at the same time as the redundancy. So there'd be zero notice or minimal notice, but it would be the HR1 would be filed at the same time as effectively the dismissal, if that was what was regarded as being the necessary course of action. But to say that Hartlebury led to a change, and appreciate that Hartlebury was concerned with collective redundancy, but Hartlebury led to a change where the practice of administration meant that suddenly there will be a compliance with the collective redundancy obligations under TULCRA and a compliance with the obligation of notification. Not at all, so far as I can see or am aware. I think it's right, and I haven't gone to this because so far as I'm aware, nothing's ever happened about it. At the time the prosecutions arose in the world of administration, there was quite a lot of concern about it, and there was a consultation promulgated by the government about the intersection between insolvency and collective redundancy, which, as far as I'm aware, has never been concluded or produced a result on. And because it sort of arose as an issue prompted by these prosecutions and then slightly faded into the back. So this tension between collective responsibility collective redundancy consultation and administrative has never really been fully grappled with. I suppose it's possible that and this is just a broader answer to the question, in a post-Brexit world, the obligation under the directive could be departed from by government to consciously change the position about obligations. As Hartlebury rightly recognised, as it stands, the directive didn't permit a separation other than the possibility of allowing a state, in case of decisions made by judicial decision, to step away from the directive. But that's the sort of broader answer to the question. So the first answer, and I'm sorry it was a long answer, is that if there was something straightforward which could assist with that, we'd identify it, but we don't believe there is. Second question, in a sense, the point already made to an extent for me, in relation to section 212 of the Insolvency Act. And bear with me a second. And it is, I entirely agree with my learned friend that the sequence of events appears to have been that the original drafting of section 212 included administrators in the subsection 1B of summary remedy against delinquent directors, liquidators. When the Enterprise Act introduced the new schedule for administration, it introduced paragraph 75, the paragraph that I took you to, about how the court had a power over administrator to deal with any effective misconduct on their behalf. So there was no need, or rather there was a separation to take administrators out of section 212 because there was then a separate code to deal with, in the Act, any misconduct on the administrator's behalf. But I think the point, which as I understand it, Lord Reid put to my learned friend, the point is the delineation. It's the third element, together with the previous examples we gave, that when the drafters of the legislation were formulating it, and of course, I acknowledge, of course, that they were formulating it both in the knowledge of the existence of rebuilders, Johnson Builders, but also the other cases my learned friend referred to. The drafters of the legislation clearly saw that there was a distinction between being an officer of the company and the status of liquidator, administrator, or administrator receiver. And it's merely the separation of administrator that's just taken it to a different bit of the legislation, but entirely consistent with our argument that when one looks at the legislation, what one sees is nothing that supports the contention that someone would be an officer of the company. My learned friend...
So there are clearly, on your submission, no provisions that you're aware that expressly include, within the concept of officer of a company, an administrator?
No. Certainly, I'm not aware of any in a broader context, and certainly in the context of this legislation, none at all. And specifically within the concept of Schedule 1B, defining the role and status of administrator, absolutely not. The only thing it tells us is that the administrator, as an officer, is an officer of the court.
Thank you.
I thought that the home treat and powertrain cases were examples of the term officer being regarded as including administrators.
Sorry, I think the question was whether or not there was an express provision within the legislation.
What you're talking about the Insolvency Act alone.
And so I don't disagree that that line of authorities adopts an interpretation that includes administrator. That's as a matter of interpretation, but expressly included within the Insolvency Act, or indeed expressly articulated, it doesn't. Can I come back to those cases? I will do very briefly. But the third point I wanted to make in reply, which is really the heart of my learned friend's argument, which is to say, well, this is a functional test. And what one's concerned about is identifying in the section who is functionally responsible for serving the HR1 notice and attributing a criminal liability in relation to them if they fail to do so. Well, the fundamental problem with that is that what he has to grapple with is the wording of the section rather than the wording of the section as he wants it to be. And had Parliament wanted a functional test, it could have said that a criminal offence could be committed by those who connive whatever, who had responsibility for the service of the notice, and that could have embraced a wide range of people. But actually Parliament was clearly intending only to capture people who had a certain status within the company for that particular responsibility. So his problem will always remain similar officer of the company. And you don't need to hear me further on the primary interpretation of the Insolvency Act as to why we say it doesn't define them to be an officer. As to the line of cases, and
So what, and the content that you give to similar officer in that provision, what is that then?
the content that I give, that I say that of similar officer means that they must be an officer of the company, and it's contemplating other types of officers of the company. I think my learned friend accepts that there could be examples, for example, in relation to foreign companies in the United
Because the
Kingdom.
word is not company, it's body corporate.
Yes.
So
there
it
could-
includes all foreign incorporated companies, and it includes all domestic corporate bodies which are not registered companies.
Correct, which will have different officers.
Yes.
And therefore it's got a purpose, but all of them have a status as officer.
Yes.
So I think, so it's not redundant as a phrase, but it is commensurate with the status within the company rather than of the company. Sorry, over the company, sorry. Can I very briefly deal with just that line of cases and take the practical point, which I suppose is a sensible starting point, which was a point made by my Lord Richards, that actually, although in fairness at the time it may not have been as open, there isn't really a need for the mental gymnastics of trying to work an administrator into the definition of officer for the purpose of the Companies Act, because, as was pointed out, in the modern structure of administration, if an administrator was concerned about whether or not they might be open to misfeasance because they were conducting the affairs in the home treat example, where the case was that the conducting of a nursing home was not within the original objects of the company, they went to the court and got a direction to conduct the business, then they couldn't be subject to misfeasance at all. And so, on one level, one needn't be worried about a side wind of exposing administrators to risks of the type of criticism, of the type of claim that was being addressed in Powertrain and Rehome Treats, where it was a view was necessary to interpret the relief of some sanctions for company under the Companies Act to include administrators. It's not really necessary. But my real point...
But are you saying then that if we were with you, that the administrators are not officers of the company for the purpose of this provision, that doesn't undermine the decision in Home Treat?
Well, I don't need you... For my purposes, I only need to look at whether or not they're an officer for the purposes of this particular section. That line of cases is concerned with a different section. Although I don't see there's a problem with them not being officers for that line of cases, because there is now a ready solution for the purposes of administration, which enables administrators to avoid the risks of claims against them by seeking direction of the court. That would have been the solution.
I mean, they did, I think, in Home Train, Mr. Justice Harman made two orders, he says. Looking at the report, that would appear to be first a direction under Section 14 of the Insolvency Act, as it then was, and secondly, the relief from sanctions under Section 727. So those applying for the order perceived a need for that extra order, but it's still not clear to me exactly why that was needed.
Yes. What I primarily say about the line of cases, and my learned friend used an interesting phrase. He talked about the number. The slight problem with number is the foundation upon which they're built. And when you go back to the foundation upon which they're built, one goes back to Re-Ex, and with the greatest respect to Mr. Justice Parker at the time, and while one might understand it, there's really precious little reasoning at all in relation to Re-Ex as to why in that particular case it will be considered that the liquidator would be a officer of the company. I think it's in the bundle, the electronic bundle at page 375. And there is no real reasoning other than Mr. Justice Parker saying that he's giving leave to file what was a document to which tax would be due on the basis that they might be liable to penalties under the Companies Act.
It says on the footing that he is an officer of the company.
So again, it's a slightly belt and braces set of circumstances where, and in fact, when you determine when you scratch down to the facts, what seems to have happened is during the course of argument, it became apparent that if in fact the underlying agreement upon which stamp duty was payable had been annulled, the stamp duty would be paid back, and the main interest of the person pursuing the litigation was the creditor. Was a creditor of the company who wanted to get the money back.
Yes. I note from Mr. Justice Harman's judgment, he quotes Buckley as saying, assembly, a liquidator is an officer, which I think Lord Burrows will know better than me is one of those polite ways of saying this is slightly dubious.
That may be a fair observation. Certainly my observation is that it doesn't bear a lot of scrutiny in terms of reasoning. And again, no disrespect to Mr. Justice Harman in Rehome Treat. Again, there seems to be quite a leap from officer of the court, responsibility in terms of management, to being officer of the company, built again on Re-X. Powertrain again.
It certainly doesn't analyse the provisions of the 1986 Act in the way in which we've done in the present case.
No. And again, Powertrain, and Mr. Justice knew as he was at that particular time, again, we can see that there had been some uncertainty about the status of liquidator. There's a reference to a judgment of, I think, a judge formerly of this court, His Honour Judge Berrens, sitting as a Deputy High Court judge, that has a reference to questioning whether or not a liquidator was the officer of the court. And in Powertrain, again, there's a reference back to the same line without ever any real reasoning. Schofield and Smith, I respectfully say, is of absolutely no help whatsoever. It's a settlement agreement under which there's a definition of released parties, and affiliates are defined to be officers or agents, and the Act tells us they're agents for the purposes of the release. I think it takes us nowhere. So I don't demur from taking light the cases as they stand. I remain to my original position. Can I just finally deal with the question of special circumstances? And really, with great respect to my learned friend, what he really confuses is the position of any special circumstances attaching to the individual administrator and that of the company. And the complete clarity, what we can see that confusion, was when he talked about the knowledge of the administrator as being relevant to the status of the special circumstances. How can the knowledge of the agent in the conduct of the affairs of the company be relevant to the status of whether or not special circumstances are maintained for the company? If special circumstances had been included as a specific defence for the individual, I understand some force in that, but unfortunately it isn't. If the offence is there, special circumstances has to be capable of being advanced by the company. That is all that I wanted to say by reply. I've never been criticised for being shorter than my allocated
You're not going to be criticised now either, Mr. Reid. Thank you very much, Mr. Reid. Are there any questions? No, thank you, Mr. Reid. Well, we're most grateful to counsel and to those who've assisted them. It's in some ways quite a short point, but quite a challenging one. We'll let you have our decision as soon as we can. The court will now adjourn.